Welcome back to Differences, where we break down the world's most important topics. Today, we are diving into the fascinating world of legal systems, common law versus civil law. Stay tuned as we explore differences, similarities of laws and explanation. Common law. Common law is not codified law. While civil law. Civil law is a codified set of laws. Judicial precedents are binding in common law, while judicial precedents are not binding. In common law, judges make rulings, set precedent, and moderate between the conflicting parties. In civil law, judge's role is to establish the facts of the case and to apply the provisions of the applicable code. Common law main source is judicial precedents or case law, while civil law, statutes and other subsidiary legislations are the main sources. An adversarial system in common law, while an inquisitorial system in civil law. Now start the explanation. When one looks into the legal systems prevalent in the world, one may come across many legal systems practiced in various countries, which bear their roots from the legal systems practiced in the European continent. Though all legal systems have the same purpose of regulating and harmonizing the human action within their respective societies, these legal systems are all driven towards certain fundamental likenesses and differences in their lawful frameworks. Most countries today follow one of the two most prominent legal systems, common law or civil law. The common law system developed in England amid the Middle Ages and was applied to the former British colonies across the world. And the civil law system created in Europe was applied in the colonies of European imperial powers such as Spain and Portugal. What is common law? Common law is largely uncodified. This implies that there is no complete compilation of legal principles and statutes. Thus, a common law system is less prescriptive than a civil law system. While common law relies on few statutes, decisions of the legislative authority, it is extensively based on precedents or the judicial decisions made in comparable cases, generally the decisions of higher courts, which entrust the judges of the common law system with enormous role in shaping the law. For instance, the elements expected to demonstrate the crime of homicide are contained in the case law, as opposed to the law characterized by statute. To ensure uniformity, courts follow the precedents set by higher courts in cases dealing with similar matters. These precedents are recorded and are documented as case laws through yearbooks and legal reports. Common law functions as an adversarial system where the judge acts as a moderator between the two conflicting parties. Common law systems can be seen in the previous English colonies such as Australia, India, Sri Lanka, Canada, and the United States. Common law lawyers claim that their system is more flexible since it can adjust to circumstances without any legislative interference. What is civil law? The civil law is codified and has its origin in the Roman law. Countries with civil law frameworks have a wide-ranging and a constantly updated legal principles that encompass all matters fit for being brought before a court, the relevant procedures, and the fitting punishment for every offense. Such codes recognize distinctive classes of law. Substantive law builds up which acts are liable to criminal or civil prosecution. The procedural law lays down the rules for determining if a specific activity constitutes a criminal act, while the penal code specifies the punishments and penalties for certain acts. In a civil law system, the judge's part is to build up the facts of the case and to apply the statute law, thus making legislative enactments binding. Although a judge brings the formal charges, investigates the matter, and provided the verdict on the case, he or she functions within a framework of codified and structured legal rules and principles. Legal personalities in civil law jurisdictions believe that their system is more steady and reasonable than common law systems since the laws are expressed explicitly and are easier to determine in civil jurisdictions. Main sources of law. Common law, the main source is judicial precedents or case law. Civil law, statutes and other subsidiary legislations are the main sources. Court practice. Common law, the court practice is an adversarial system. Civil law, the court practice is an inquisitorial system.